Let's talk about the testimony of one of the first witnesses to see Riva. It was Dr. Johan Stipp, and he says that Oscar was leaning over her, crying and absolutely distraught.
Yes.
Now, what the state will probably argue is that you can intend to shoot somebody and still be distraught.
Yes, obviously. Or you could kind of make it up. In other words, he's now has intended to kill her. He knows somebody's going to arrive, so he's got to kind of put in place a situation and show a condition that would indicate that there wasn't any planning, there wasn't any intention, and that it was an accident. But you're quite right, even if you have planned it, even if you intended to shoot, lose your temper, and then intended to shoot her and kill her, you could afterwards suddenly realize, oh my gosh, I've done something wrong, you have regret, you break down in tears, you are emotionally upset. So I suppose it could swing both ways, but certainly it could also show that he's genuinely upset because it was an accident.
Now, this particular witness, Dr. Stipp, is a neighbor of Oscar Pistorius, but also he's a radiologist. He has medical training.
Yes.
And he spoke in no uncertain terms. He was very clear and he used medical terminology. Will that type of testimony hold more weight in court?
Well, I think so, if it comes down to technical medical evidence. But the fact that you're a doctor or you're just an ordinary person, a laborer or some other professional, relating to what you've seen or what you've heard, what you've observed, doesn't make you now an expert in observation. You're an expert in your particular field. So if he's telling the court about what he observed which relates to medical issues, in other words, he arrived on the scene and this was her condition, and he gives opinion evidence about that. That obviously places him in a different position to just any other person. But if it's about what he heard or what he saw, in other words, seeing Oscar's state, what he'd heard before about various issues and the noises and all of that, then that doesn't make, because he's a doctor, that doesn't make him any better than any other witness.
He also said that the investigating officer at the time, Hilton Botha, bungled his statement. He said that Hilton Botha said that it was an official statement, it was done while he was under oath, and he says that it wasn't. Now, can police mistakes like this sway a case?
Obviously, and many times I've noticed in court that you get the most atrocious statements that have been taken by police officers, and witnesses are confronted with these statements and say, but hang on, I didn't even sign it, or I didn't say all those things, or I did say things and give factual information which is not included in the statement. So the fact that a statement hasn't been signed where it should be under oath, then it could cause a problem, but it doesn't mean that that will necessarily amount to the judge finding that his evidence is not to be relied on. If there are discrepancies, then that could affect the evidence of a witness, except, of course, if the witness can explain, listen, it's not my fault. I'm not the one who's making mistakes or he's not a reliable witness, but it's the police officer who didn't take down the statement properly. So this is a very important aspect, and it occurs often that the statements are not taken down properly. So investigators need to get their act together in this regard. There's been a lot of criticism about the police and how they've investigated cases here, also how they arrived at the crime scene, how they didn't seal the crime scene, and all of that which could affect the validity and the acceptability of forensic evidence. I mean, if it's not properly taken, if there has been possible contamination, that could have a major effect on forensic evidence later on.